Well, my name's Richard Lozano. I'm Head of Employment here at Taylor Bracewell. The phrase unfair dismissal isn't always very helpful. The legal test for the fairness of a dismissal isn't whether the dismissal is fair or not. Instead, there's a number of elements to it that need to be borne in mind. The first is is it a fair reason for a dismissal? So, for example, is it on the grounds of capability, on the grounds of conduct, statutory illegality, redundancy, and so on. So it has to be for a potentially fair reason, first of all. Then an employer's got to follow a fair process before dismissing somebody. Now, it depends on the type of dismissal, but for example, if it was a misconduct situation, an employer would need to undertake an investigation first, a reasonable investigation, to establish whether there was any wrongdoing. So that's the first thing they would need to do, and then follow a fair process in terms of having a disciplinary meeting with the employee, and then beyond that, if they decide to dismiss, they would need to offer an appeal as well. If the employee doesn't have a fair reason, doesn't follow a fair process, and the employee has more than 2 years service, then in those circumstances, potentially the employee could bring a claim for unfair dismissal.